So today we have a webinar that is about stuttering and employment law. This is an important one, see, because people who stutter, we face challenges in all phases of the workplace, ranging from job interviewing to daily interactions to just having conversations with coworkers and supervisors, as well as to career advancements. This webinar will discuss basic employment rights of people who stutter, how to access and how to ensure those rights, as well as give you guidance on workplace accommodations under the Americans with Disabilities Act. We have two expert hosts. On the screen right now you see Mitch Tryshon, who is an SLP, PhD, CCP, and a PTP, or that's a primetime player. As well as we have Greg Chiarello, who is an employment lawyer at Oughton and Golden. They will be the experts for this. And right now, I am going to hand this talking portion over to Mitch Tryshon, and he will do some introductions of himself and Greg and kick right into the webinar. Mitch, it's all yours.
Thank you, John. Thank you for the introduction or for handing it over. Before I introduce Greg, I just want to give a brief background about myself. I'm a member of the National Stuttering Association's We Stutter at Work Employment Advocacy Committee. I've been on the board of the directors of the National Stuttering Association and the International Stuttering Association. Have nearly 15 years of speech-language pathology teaching experience and currently teach at a university in New York City. Have presented over 50 presentations on stuttering-related research, including co-keynoting at last year's Joint Congress in Japan. I'm a co-founder of Stutter Social, which is an internet-based community of people who stutter. And as John said, I'm a speech-language pathologist and a person who stutters, who works within the New York City Board of Education and also has a private teletherapy practice. Now to introduce Greg Chiarello. He is a partner at the New York office of Oughton and Golden, which is a firm dedicated to championing employee rights. He is the co-chair of his firm's Family Responsibilities and Disabilities Discrimination Practice Group, and also is a member of the Sex Discrimination and Sexual Harassment Practice Group. Mr. Chiarello represents employees with disabilities, including employees who stutter in a wide range of capacities, from behind-the-scenes counseling to litigation and arbitration. I'm glad to be involved in this presentation because this is a topic that's very personal to me, because in my previous career as an accountant, I experienced some discrimination in the workplace and was felt pretty lost on what I should do. So without further talk from me, I'd like to introduce Gregory.
I want to say first, just thank you for having me for this webinar, especially on International Stuttering Awareness Day. Happy ISAD to everyone, and thank you for having me speak on this day in particular. Mitch noted I'm an employment lawyer. I devote a fair amount of my practice to disability rights advocacy, and I've worked with a number of individuals who stutter and am familiar with some of those issues, and I'm now also getting a little more involved with NSA, which is really a great organization. So happy to be here. What I want to do today is talk at a very high level about some of your rights as an employee, as a person who stutters, and by extension as someone who's protected under certain laws that are going to protect persons with disabilities. A stutter under federal law in most instances is going to be a protected disability. It's not always going to be the case, but generally speaking, it is. And so with that kind of threshold assumption, we can talk about some of the rights that folks have. A couple initial caveats. One is that I'm going to be talking about the law and some practical considerations you might have. Nothing I'm talking about today should be construed as legal advice per se. These are some thoughts to consider, and I would say, speaking with a lawyer or thinking through your specific situation is the way to go before actually employing any of these tactics, but you should at least sort of think about those things. Because we have kind of a limited window of time, if folks have questions, they should feel free to type them in the chat box or send them to me and Mitch, and we'll devote some time at the end to discussing them. And hopefully Mitch is going to interject some questions also. But I want this to be as useful for the audience as possible, so don't be shy about asking questions. The more specific the question, probably the more helpful I can be. So I'm going to toggle back and forth between a PowerPoint, although I think mostly it makes sense for me to just do some talking here. But as a person who stutters, I guess the initial question is, what are your protections under law? And when I say law, I'm talking about something called the Americans with Disabilities Act, which is the federal law that protects against unfair treatment and discrimination for persons who have disabilities. Depending on where you live, and I understand that this is potentially a national audience, most states have their own anti-discrimination laws, and those would cover, in most cases, disability. Some locations like New York City has its own anti-discrimination laws within that. And so there may be additional protections, but what I'm talking about today is at a very high level federal law. One, because it's going to apply to everyone, and two, you're not going to have fewer rights under federal law than you are in another situation. In other words, your state law might be more protective, or it might mirror the federal law, but it won't be worse than the federal law. So we're sort of talking about the baseline of your protections. So there's really two pieces that I think come out of the ADA. One is that as a person who has a disability, and here we're talking about a stutter, your employer can't treat you differently than it would another employee who does not have the same condition or the same disability. And so that means, in a general sense, that you can't prefer one employee over another because one employee has a disability and the other does not. That is at sort of core what the ADA is protecting. And so you can't fire someone because they have a disability. You can't pay them less for the same job because they have a disability. You can't treat them worse because they have a disability. The key is because of the disability, right? And so that's, I think, often where the nuance comes in. And I'll try to talk about essentially a hypothetical scenario in a little bit that maybe gives you a little flavor of the circumstances I'm talking about. The other instance is, if you require an accommodation to perform your job, the ADA is going to protect you in that instance as well. So for stutterers, hopefully I'll have time to get into some of the specifics, but there may be accommodations that make sense for a person who stutters. For example, having additional time, receiving instructions in writing, you communicating by email instead of by telephone, taking time off to see Mitch to have speech therapy. Those types of things might be considered reasonable accommodations. And the fact that you're requesting them shouldn't be used against you. And, if the request is reasonable, which I think there's a little gray area, but generally what I described would fall into the category of reasonable. Your employer has to allow you to have those accommodations if it's going to help you to do your job. So that's kind of the high level. I talked about this a little bit, but just some of the conduct that might fall under the rubric of impermissible conduct under the ADA. So just some examples of impermissible conduct, and I'm going to try to not stay in this mode so much, but not receiving a promotion because you stutter, being paid less, being made fun of, harassment. I think that's a common complaint that comes to me. Being denied a reasonable accommodation, losing your job, being demoted, or receiving a pay cut, any adverse action because you make a complaint related to your treatment as a person who stutters as well. And so we'll talk about this all a little bit more in a second. While I'm in this mode, what I want to do is just set up a hypothetical for discussion. And so let me run through a couple slides here and just talk quickly. So this is a hypothetical scenario of an employee, a couple of things that Donald goes through, and then we can talk about what he can do and what his rights are. So Donald is an analyst at a major commercial bank who has stuttered since he was a child. His stutter can cause long pauses in his speech. His coworkers describe his stutter as obvious and say that sometimes Donald's stuttering gets worse when he participates in telephone calls or makes presentations. However, Donald's work product is excellent, and he has received good performance reviews and positive feedback from most of his managers. Notwithstanding his good performance, Donald's work life is difficult. Some of his coworkers make fun of him because he stutters. They taunt him with phrases like, "Sing for us, Donald," or tell him to spit it out when he's having difficulty speaking and when he's stuttering. After a while, Donald complains to human resources. The office bullies back off, but do continue to tease him occasionally. Not long after raising with human resources his concerns of being teased about his stutter, Donald begins receiving less work from his managers, and in the next performance review receives a below expectations rating. The review cites lack of productivity and communication as areas for immediate improvement, but he is given little in the way of guidance or specifics. A few months later, the bank fires Donald, claiming it is due to poor performance. So the first takeaway, which I think is maybe fairly evident, is that making fun of somebody with a stutter is illegal. And I think some employees feel that there has to be some major event that takes place. They need to be fired for there to be potentially a claim, or they need to be not hired because of their stutter. And those are certainly situations in which discrimination can occur. But the day-to-day making your life miserable, the making fun of you, the making your life harder than it needs to be, is protected under the law. It's called harassment. And in the same way, harassment based on race or sex is impermissible. It's true for anyone with a disability as well. I'll also note that the ADA protects against discrimination because of an actual disability and also because of a perception that you are disabled. And I think that is where the coverage under the ADA is broadest, meaning you don't necessarily need to have disclosed that you have a disability or that you are a stutterer if your employer infers based on your manner of speech that you have some disability without even articulating the specific disability and treats you differently on that basis. That's also protected under the law. So the second takeaway and sort of the second point I would say for Donald is what should he do in that situation where his coworkers are making fun of him? I would say he did the right thing in that he raised his concerns with HR. And there's a couple reasons for doing that. One is the problem isn't going to get fixed if it's not raised. For the for an employee for someone to actually receive relief in that situation, they need to bring it to the employer's attention, and then the ball is in their court to fix the problem. If they don't fix it, that may be an independent basis for some action. They need to be aware of it, and there's actually, in the case of a harassment claim, defenses that employers have where the employee never raised the issue for the company to address. So you need to raise it. The way I would suggest raising it is in writing, because it gives you an additional benefit. So one, you're bringing it to your employer's attention, and two, there's a record of it. There's an indisputable record of when you made the complaint and what you said. And so if, as what happened with Donald, right, he ultimately winds up getting fired, there's no dispute that he had raised a complaint and when he raised his complaint. And so then we can look at when that happened and what happened afterwards and see, is this related to his complaint, or is there actually a performance issue that's suddenly rising here? I think it's important to think about where you're raising the concern. So certainly human resources is an option. But I think the takeaway I would suggest is, where is there the ear of reason? So maybe that's your manager or your manager's manager. Does the company have an anonymous complaint line that you can call into? If you're in a union, is it possible to grieve? Thinking about who is going to be the most sympathetic ear, the most receptive ear. HR often is, in my experience, is sort of a buffer between employees and the employer. And so someone who isn't immediately thinking, how do I protect the company? Not to say that HR is the wrong place to go, but just thinking what makes the most sense in that situation. Okay, so let's say you report let's say it's harassment here, but let's say it's, or there's a promotion, right, that you thought you were the most qualified for. And just to sort of twist the situation with Donald, they come back and say, you know what, you need to work more on your communication skills, but next time we'll get them, even though your numbers and your sales are much better than the person who did receive the promotion. What would you do at that point? Well, I think there's a few options. I mean, certainly talking to a lawyer to sort of see your options makes sense. But in terms of advocacy, there is something called the Equal Employment Opportunity Commission. It's the federal agency tasked with investigating violations of federal anti-discrimination law. And so it's easy enough to go down to that office and make a complaint, and potentially they will investigate it. At a minimum, you're putting on record your concern with your employer, and they may or may not investigate. That's a longer discussion, but it is a government agency, so just keep that in mind. But there are also state and sometimes local agencies tasked with doing the same thing. New York has the New York State Division of Human Rights and the New York City Commission on Human Rights. They're tasked with enforcing their own respective laws. But it's the same concept. It's going down and making a complaint, and having this agency investigate and potentially remedy the situation. It's a worthwhile thought, because it's a zero-cost proposition, meaning that it's you've already paid for it through your tax dollars. It's not like retaining a lawyer. The other option, which we could probably spend a whole webinar discussing, is taking legal action. And I think that's a step that requires some thought, but that is often the way in which rights are vindicated, in which public examples are made. And that is sort of the alternative, right? So that to the answer to the question, if I have a legal claim, what do I do? In theory, you could file a lawsuit, although often there are ways to kind of address the situation before that's necessary. So let me talk about one more piece, which is, in the hypothetical, Donald is essentially retaliated against for having made a complaint, right? Once he complains, he stops receiving work, and then he has a bad performance review in which he's told he's not doing enough work. And it's a little bit simplistic. I think real life is sometimes more complicated. But the idea is, once you make a complaint, as an employee, you're supposed to be protected. Your employer is supposed to be looking out for you, but that may not be the case. And so it's about being, I think, a little more vigilant and paying attention and looking for signs that the tone has changed or the attitude has changed, and possibly addressing that issue before you reach the point of them actually separating you from your employment. But it's illegal for an employer to retaliate against you because you've made a complaint. It's illegal for them to retaliate against you because you've asked for an accommodation. And so you should feel comfortable asking for those things. Is it 100% risk-free? No, I wouldn't have a job if that was the case, right? But it is what is supposed to happen in terms of being protected. And that's one of the things I try to police in my job. Mitch, at this point, I'm going to talk quickly about accommodations, but did you have something you wanted to add?
Yeah, I actually had someone within the chat asked, are there any situations where a person who stutters is not protected? Like if in the job description, if excellent verbal communication is a requirement of the job, or are there any situations where stuttering is not protected?
So under federal law, the definition of a disability is an impairment that substantially limits a major life activity. So it's these three components, and I sometimes in this presentation kind of break that apart and talk it through, but for the sake of time, I've pulled it out. But the key piece is, substantially limits. Generally, stuttering is considered an impairment. That's not really an issue. Major life activities are things like speaking, communicating, all of that is generally satisfied. The question is, how severe is it? And so to answer the question, in some situations, a mild stutter may not qualify as a disability. To the question we received, in another context, if someone is unable to perform the essential functions of their job with or without accommodation, then there's no requirement that they remain employed. So to put that in a context, there are some cases where essentially law enforcement who are emergency responders who need to be communicating in very intense situations, courts have upheld that that's not going to be a situation where a stutter is a disability, but it's not a disability that is protected in the sense that the employer has to provide a job to that person. So I think in cases of very mild stuttering and in very sort of severe cases where it is a direct relationship to the job, but there's a lot of room in between. And I want to be clear that, for example, a sales job, right, that requires you to potentially cold call or be on the phone with people, just because talking to customers is part of the job doesn't mean that there's an employer can say, well, you don't meet the basic requirements, so we don't have to employ you, or that's a job in which, as a person who stutters, is not qualified to perform. Something that one of the plaintiffs in these cases said, which I thought to be both true and also eloquent, was that as a salesperson, he found that he actually made more sales and did well because of his stutter, because it forced the person he was speaking to slow down and actually listen to what he was saying. And so I think, it doesn't necessarily mean because the job has speaking that you are not qualified for that job. And in fact, I think there are sort of ways to think about your stutter as being a benefit in essence, or certainly not a detriment in approaching those jobs. So we talked about kind of the extremes, but I think most employment is going to fall somewhere in between and is going to be protected.
So a personal question I had is, and this probably applies to others also. So a situation that I was in was I was on a job where I was being harassed, and because of the harassment, I decided to leave the job. I'm wondering, do your rights change if you leave the job versus if you stay on the job?
Yes and no. So your rights don't change, but I think the nature of what your potential legal claim might be changes. And so in a situation where you're on the job and you've been harassed, that is a wrong in and of itself. And whether you stay at the employer or not, that is potentially a cognizable claim. Resigning, generally I don't ever advise clients to resign. There are situations that are intolerable, and so sometimes it's necessary. But my view is if they don't want you there, then the employer needs to take the action. You shouldn't just leave. And from a legal perspective, it may affect how your claim is addressed ultimately if you resign, because one, you're taking off the table potentially a more serious claim, right, like a termination claim. And two, I think it disincentivizes employers. So I look at it more from maybe a bargaining position, right? That by staying in the job, you have the leverage of being in the job. And if what they want is for you to leave instead of you giving them that gift, right, you sort of put them to task to actually pull the trigger or negotiate something with you or fix the problem. But if you leave, right, there's not a lot of incentive for the employer to address things with the harasser, because there isn't going to be that issue anymore, right? It's sort of just, Mitch is gone. We don't have to worry about it anymore. Maybe they say something in retrospect, right, if you talk about it in an exit interview, but it's not the kind of thing that, they're really going to take as seriously as if you're still there and they have to face it.
I think it was more a matter of the guy just didn't know that how insensitive he was. I don't think it was a matter of them wanting to get rid of him. He just was very insensitive.
Just to get back to what you were saying a second ago, Mitch, in your situation, I mean, I think, if the person who was being insensitive, if you didn't raise the issue with that person, or probably more appropriately, somebody above him, right? This is what I was talking about earlier. Nobody's going to be able to address it if you don't speak up. And that I think is maybe the hardest part for a lot of folks, is just taking that step, because after that, the machine is rolling, the ball starts rolling, and it's a little bit more of a responsive thing. It's about taking that first step. And honestly, that takes a fair amount of courage.
Someone asked about assuming that stuttering is a disability. Someone says, your presentation assumes that stuttering is a disability. Therefore, we allegedly covered under the ADA. Has it been legally established that stuttering is a disability? And I think that you would agree that it is covered under the ADA, correct?
Correct. But it gets back to what I was sort of saying earlier in terms of it being an impairment that substantially limits a major life activity. And so, the sort of middle piece is this substantially limits. I'll tell you the courts have looked at that in a much more generous way in the last 20 years or so. And I would say in most instances, it's going to be covered. The other reason I'm going to say it's covered is if your stutter is in any way detectable, there's a very strong argument that you are perceived as disabled, right? The moment they're sort of thinking or considering your stutter. So between those two, I'm hesitant to say that yes, every stutter is going to be considered a disability. It's because stuttering operates on sort of a spectrum. It's not necessarily the same as other disabilities that just either are or not. They're more black and white. But I would say in most instances, yes, it's going to be covered.
And as a speech pathologist and a person who stutters, who's been very involved in the stuttering community, I can say that stuttering can be a disability, and it is the goal of people within the stuttering community and people who treat people who stutter to have stuttering be less disabling. So the more that you work on various aspects of not only stuttering but overall communication, you are reducing how much stuttering can be disabling. So the goal is to have it be less disabling. But yes, overall, a stutter can be disabling.
Towards the beginning, there's a question that asks, if you don't disclose that you stutter at the time you're hired, will you be covered? Meaning, are you still protected by the ADA? And somebody said yes, and that person is correct. So it's not as if disclosing it creates the protection in the sense of whether or not the law is going to protect you. There is an element of, so this comes up in the context of mental health disabilities a lot. So if someone is suffering from depression, which is a disability covered by the ADA, unless they disclose it, right, their employer may not know that. And so, it gets to the issue of if somebody is being treated differently, is it because of some legitimate reason that's not discriminatory, or is it because of their disability? So in mental health situations, it can be a little challenging, and so that's where disclosure maybe sometimes makes sense. And in certain contexts, certainly in the context of asking for an accommodation, stuttering, I think generally is going to be on some level self-evident, but it's not as if the law only exists if you disclose. I guess the better kind of counsel here would be if there are concerns that you have, right? The question is whether you should disclose. And Mitch, you and I talked about, the timing of things like that, whether, for example, in a job interview or ahead of a job interview or after you've been hired. And I think it depends on the individual. But my view is, it's sort of an as needed thing. There isn't a requirement that you disclose, and I would only recommend disclosing if you think it's to your benefit in some way. Otherwise, I don't see for anyone who has a disability really the benefit of making it sort of an issue at the forefront, right? Sort of identifying who you are. I would much rather employers look at employees as opposed to someone with a disability.
Pam Mertz made the point that what we're talking about here is within the US. You really need to check your individual countries to see what is and is not protected under the laws of your own country. So I thought that that was a really good point.
That's right. I didn't know we had international participants, which is pretty cool. That's cool.
If I could bring up another topic, because what we've been talking about so far is employment. I'm curious about interviewing. If we shift this question to, is it a good idea to disclose your stutter during an interview? Is that something that could be helpful or hurtful, or is there any light that you could shed on in terms of disclosing your stutter during the interview process? In the realm of self-help, we talk about disclosing your stutter and how that could be helpful. But from a legal standpoint, I'm curious to hear some of your comments, if any.
Sure, and I think this is a good topic for us to talk about. So my viewpoint is that there isn't, sort of similar to what I was saying a while ago about once you're employed. So you're protected under the ADA, just to back up, during the interview process and the hiring process. And so if you are not hired because you have a stutter, that would be illegal as well. In terms of when to disclose, I think it's more personal preference. I maintain the view that it's only if there's some benefit that to you to do it. So if, for example, ahead of an interview, it would be helpful to alert the interviewers that you're going to need some accommodation, or I've heard folks at NSA say, it gets it out there so that nobody's kind of thinking about the elephant in the room. I mean, I think if you think that's helpful, then that would be the way to do it. Certainly if there's something that you need from the employer prior to the interview, right? We need some accommodation for that call or that in-person interview. Otherwise, I think my view is not to, ignore it, but just talk about it where it finds its place. And Mitch, I'll credit you with this. You actually made a very good point that in an interview, it can be a way to talk about challenges overcome, or an example of a difficult situation that you've navigated. Some of the kind of more general test your mettle type questions that you might get in a job interview. But I think in a job interview, I think it's if it's not apparent, I think it's up to you. But I think only if you see a benefit to disclosing it. I think if you think it's going to make the interviewer more comfortable, from a legal perspective, I think disclosing later rather than sooner is helpful, because if you're going through rounds of interviews and then suddenly it stops, or everybody's very excited, over email, but then when they meet you, it's sort of a different feeling, right? That might suggest that the stutter is what's causing the change in tone. And from my perspective as a civil rights lawyer, why make it easier for them, right? And so if you let them know ahead of time that you have a stutter, it just gives them time to come up with excuses about why they're not going to bring you in the first place. It's very difficult to prove why someone is not being hired because of a stutter. It's a difficult claim because there's so much information we don't have. We're not, we might know who gets hired, but in a pool of candidates where resumes are similar, but there are ways of distinguishing every candidate, the employer is going to come up with a reason that is nothing to do with any real life experience, hiring is generally kind of a speculative process in and of itself. So we may not have information. There's a lot of leeway, I think, there. It's hard to necessarily pinpoint that down. But I do think providing that information later rather than sooner draws them in, draws you in as a candidate. And then if we see a lot of positivity and suddenly they learn you have a stutter and the tone changes, that might indicate something is amiss.
There was a question about if there are any suggestions for dealing with savvy harassers, which are those who are really good at cloaking their aggressive behaviors in harmless comments. That's a tough question.
Yeah, so I mean, there are, so a colleague of mine used to say discrimination is irrational, meaning, you know, we're not always going to know what somebody is thinking. People don't always say, you know, overtly what they're thinking in terms of, you know, I have a problem with your stutter or whatever. Someone is able to read my mind because they just use the word microaggressions in the chat. You know, it's about paying attention to what's happening and how are people being treated vis-a-vis you, right? And so when things don't make sense, or, you know, people who are on equal footing are being treated differently, or, you know, there's sort of a pattern of little nits that are sort of adding up. I call it death by 1,000 paper cuts, or dying the slow death on the vine. You know, it's not easy to prove these, but, you know, often that's where the proof will come from. If that starts happening, what I usually advise clients is, you know, you have to just start doing some record keeping, right? So if the goal is shifting and you have a conversation with somebody one day, and then, you know, the next day they say, no, I didn't want X, I want Y now. Now, you know, if you respond in an email after that meeting, we had a meeting, you said my next deliverable is X, then there's no way for them to come back and say, actually, I'm moving the goalpost. You know, keeping track of all of every meeting that you're accidentally excluded from, it starts to become a bit of a job, but you have to just keep track of what's happening, and you have to document when people are saying things, and basically have to hold them accountable. And those are always tough cases to manage, but I think if you're thoughtful about it, you can start to address those issues. And of course, as these issues are developing, there's sometimes a way to put the brakes on it, meaning, you know, they're building a case against you, but it's going to take time for them to do that. If we start calling it out for what it is, maybe that behavior is going to change.
There was another question about when is it the right time to bring in legal counsel?
It depends. It's a very lawyer answer, but I think it depends on the circumstances. I think bring in, for me, I'll just distinguish, means something different than speak to a lawyer. And so I think if the sense is something isn't right, it probably makes sense to talk to a lawyer sooner rather than later. My own approach is progressive. It's in the sense that I try to do a lot through my clients instead of appearing directly, or you know, sort of in an incremental way, so that we can always increase if we need to, but we're not sort of starting with the most blunt instrument. Because I think the goal for a lot of employees is to see if we can just fix the situation. It's not about how much is my claim worth. It's about how do we make this right. If not for, you know, these two individuals, I love my job and I want to continue my career here. So it's about, you know, thinking about what we can do incrementally. And so when should a lawyer come in, I think is a decision between a lawyer. I would say talk to someone sooner, and then that's a decision you can make. And sometimes, you know, that's what we're here for, right? We're advocates for people. But, you know, there may be a lot of steps in between talking to a lawyer and actually having your lawyer appear that may solve the situation without really escalating things or making things as big of an issue as they might be. but achieving what your goals are in terms of having the situation remedied. So, let me just talk briefly about accommodations. So in general, right, your employer must provide you with a reasonable accommodation for your disability, unless doing so would cause an undue hardship. Undue hardship is, a bit of a relative term, but for purposes of this, I don't want to is not adequate, right? Or the fact that it's going to cost them some money at all does not mean it's an undue hardship. Undue hardship is, sort of severe disruption or severe financial cost. Generally, if it's, below that, it should be considered a reasonable accommodation. And along with that, your employer has an obligation to talk to you about the accommodation you're requesting. It's called the interactive process, and the failure to engage in that alone can be a violation of the ADA. Just a couple thoughts that for things, and it's an area of representing people who stutter that I think there's room to develop, is where there are possible accommodations. And so just a few ideas I have from experience and elsewhere is, alternative modes of communication. Is it possible to communicate by email rather than by telephone? Additional time, additional preparation time, the ability to take breaks. I think a lot of this falls under sort of the umbrella of just kind of flagging the issue and addressing that elephant in the room. Asking people to be patient, I think that's a very important one, and I think it's a very easy thing that people should be doing generally, but certainly if somebody needs a little time. To take time off for things like treatment. So all these are potential accommodations. So I just want to say again, thank you for having me. It's really been wonderful. My contact information is up there. These talks always go by so quickly. So if there's anything else anyone wants to discuss, I'm always happy and available to do that.
Fantastic, Greg. This was an extremely informative presentation. Two more things. Today is October 22nd. We've kind of peppered this in a little bit. This is International Stuttering Awareness Day. If you have an opportunity, share something with someone either on social media or in person about stuttering. There's lots of things out there. That's the easy thing to do, is share something online to raise awareness about stuttering. Second thing I want to close you with, if everybody can, unmute yourself. This is the one time I want you to unmute yourself. And if you want, you can go to gallery view. And when you go to gallery view, you'll be able to see everybody in there. And just take a look at the faces, take a look at the names to really know that you are not alone. We are all here. We who stutter and those who support us are here. And if you could just say goodbye, and we will close out for today. Thank you very much for strong participation.
Bye. Thank you.
Bye, everyone.
Thank you again. Bye-bye.
Great job.
Thank you. Bye.
Thank you.
Like Greg Brady.